Wedding albums from 2020 are looking very empty, and if couples don't want empty wallets to go along with them, they can easily find themselves in a bit of a marital minefield.
Hang on. Is that better?
David and Kirsty realised in August that their September wedding with 140 guests was not going to happen. They asked their venue if they could reschedule.
And was told that we would have to forfeit our £1,000 deposit, pay a new £1,000 deposit, and also risk 50% of the cost of the new date if a second COVID cancellation was to occur. We're talking, £3,500, £4,000.
It's been a stressful few months for the couple. David, a doctor, and Kirsty, a nurse.
She's worked tirelessly throughout the last 6 months in the emergency department, and I wish she could be sitting by my side right now, but shock horror, she's at work.
Hello.
Neil and Jessica had to call off their dream wedding in Aberdeen and got married instead in a small ceremony in Stockholm where they live. Their venue still has their £2,000 deposit and wants more.
They sent an invoice for another £3,480 for the cancellation fee. And then later on, they also refused to refund the accommodation.
The Competition and Markets Authority has sent an open letter to businesses in the wedding sector. They say that if restrictions mean a wedding cannot go ahead without the law being broken, then the contract probably has been frustrated and you're due a refund.
But if your wedding can go ahead, then it is a bit more of a grey area. The CMA says that if the number of guests who can lawfully attend your wedding is much lower than what was agreed in the contract, then you could be due money back.
The only option some suppliers are giving is a postponement to their wedding. But lots of couples are simply saying, we don't want to postpone, we just want our money back. We are seeing more and more claims being commenced against suppliers because the suppliers are simply not willing to engage and are retaining large sums of money.
But what if your supplier isn't playing ball? Well, there are a number of options that are open to you. You can contact Trading Standards and ask them to mediate between the two parties. They can't force a trader to get money back, but they are a good resource for advice before escalating things further. You can try a chargeback through your bank if you paid by debit card, or what's called a Section 75 claim if you paid by credit card. But don't delay. There's a time limit on when you can raise a claim, usually 120 days. And it's not a guarantee of money back. Or you have the option of what's called simple procedure, aka taking your supplier to court. This is a serious step and there is a backlog of civil cases right now, so you could be waiting a while for a resolution. Whatever it may be.